Thank you very much. It was not pointed out that I'm the only non-lawyer here, which means I can, and I'm a politician to boot, which means I can say anything I want, whether you like it or not. Justice must not only be done, but it also must be seen to be done, well known. And what the main issue here is, of course, it is stated in the brochure that this House believes that India's judicial appointments need legislative interference. Now, the word interference is a difficult one, but I certainly think that legislative in all countries of the world that I have studied, not many, but I have studied many, and they do not have a situation like ours. There is an interaction between the bureaucracy, the parliament, and the law. And in India, it's not so. The lawyers, the Supreme Court, for example, is totally on its own. It's the parliament and the bureaucracy has no real no strength in speaking to them or about them. The Constitution recognizes and embodies a broader version of checks and balances. That is there, of course, it's well known. A limited legislative involvement, therefore, is not interference, but legitimate way to regulate the procedure and reinforce public trust and accountability. Under Section 124(3)(c), a necessary qualification for becoming a judge in the Supreme Court is that the person must be an eminent jurist in the opinion of the President. The emphasis, therefore, has always been on involvement of the legislature and executive in the judicial world. Parliament already plays a crucial role in maintaining judicial accountability. Under Article 124(2) of the Constitution, judges can be removed through impeachment. If the legislature cannot remove the judges, it is only logical that it should be a measured role in appointing them as well. Comparative constitutional practice supports the balance. No other major democratic country in the world follows the system under judges appointments, appointing judges, which is India. India is appointing judges, are appointing judges. That is not there in the world. And without any interference from elected officials who represent the will of the people. In other countries, for instance, the United States, the Senate will summon them, examine them, and so on and so forth. None of that happens here at all. Judicial independence is vital, but independence does not mean isolation. A calibrated legislative role brings transparency, accountability, and democratic confidence to judicial appointments. In other words, I think what we are saying is that at present, the Indian judiciary, especially at the top level, which is the most important, is totally a law unto itself. And there is hardly any interaction that takes place between either the bureaucracy or the parliament. All the 6 times I was in parliament, I never saw any judge being summoned or asked to explain or any such thing. It's always a feeling of awe about the judiciary. So what my argument is that we should follow somewhat, if it's not offensive to some people, the American system of having judges who are selected to go through the committee of what is the equivalent, what we call as parliament, and they call it the state. So, hence, that recognition, if that takes place, in my opinion, much of the problems today of favoritism and things like that, which have been coming regularly nowadays, that will completely go away if a person is chosen as a lawyer or as a ruler in the place. They have to be summoned before the parliament, and they should be questioned and they should be answered. There's no question of anybody being to be hurt or anything. Otherwise, it's just basically a way the country will be able to see it. This House, therefore, must believe that India's judicial appointments need legislative interference. And the interference that we need has already been mentioned by me in 2 or 3 ways. There are many other ways. Altogether, I think this is the only way by which we can improve our legal system. Otherwise, the legal system will become a law unto its own self in the way that common people will find it very difficult. Thank you very much.
Now we would like to call upon Mr. Sai Deepak to talk against our motion. Thank you.
I'm grateful to the organizers for having made the impossible possible through the composition of the panels. People who never thought that they would actually share space with you finally managed to share space with, and also we have this occasion to speak on the same subject, hopefully in the same voice. As I understand, the topic says that the House believes that judicial appointments must have legislative interference. Now, the good part about the framing of the proposition is that it does not speak for or against the institution of the collegium itself, which means, as I understand it, the way I have carved out the proposition for myself is that I am not here to defend the institution of collegium. Rather, I am here to define what is legislative interference and push back against it. That's how I see it. Because the question was not whether there's a choice between a collegium and legislative process. The question is whether there should be legislative interference in the appointment in judicial appointments. That's how I see the question. So going by that, let me start with creating some kind of a sliding scale here for people to understand what are the different options available. First is the provision itself, which speaks of the appointment by the President in consultation with the Chief Justice of India. Now, that has been the subject of at least 3 landmark judgments and subsequently 2016. You have one system which effectively creates a bubble of sorts, which is the collegium system, where judges decide for themselves on the basis of a consultative process which is internal in nature to understand how the appointments will come about, of course with some kind of inputs which may be sensitive inputs with respect to security considerations that may be received from the executive. Then there is the other end of the spectrum where the appointments are effected either by the executive or the legislature. Here the question was not about executive interference, the question was about legislative interference. And therefore, we are not on the question of whether political parties or the government of the day shall have the right to appoint or make judicial appointments. It's a legislative interference. Now that we have struck a distinction between the executive and legislature, the next question would be, what is interference here? My sense is interference would be not the right to vote, but the right to veto. If the legislature has the final word on judicial appointments, then that becomes interference in my submission, which is to say, what would that bright red line be, which if crossed would translate or transgress into interference? So you have consultation, you have concurrence. Where do you think interference falls within which basket? I would say concurrence. Which is, if you can't take a decision with respect to a judicial appointment without the concurrence of the legislature, that would, in my view, become interference. Now, this is a matter of semantics. Let's go a step behind, which is the meta question, which is, what is it that you're trying to protect? Are judicial appointments the only sui generic form of appointments which are envisaged within the Constitution? Are there no comparable positions within the Constitution itself? For instance, the Election Commission, the Chief Election Commissioner. The Chief Election Commissioner, as T.N. Seshan rightly pointed out, the legendary Al Seshan pointed out once, and he himself called himself that, and therefore no offense is meant here, which is that he was an employee of India, but not the government of India. And therefore he struck a very clear distinction between the state and the entity, the body politic. I would submit that whether it is the Chief Election Commissioner or judicial appointments, in particular to the higher judiciary, would therefore fall in largely similar baskets, if not identical. Therefore, if you wish to understand what should be the position with respect to the appointment of judges to the higher judiciary, you cannot do so without understanding what is the Supreme Court's latest take with respect to the appointment of the Election Commissioner, wherein some kind of a broader process has been conceived of. I would be in support of a position which preserves judicial independence with respect to the final say, subject to inputs being taken from both sides of the aisle, the Treasury as well as the opposition. That's how I would go about it. One of the reasons that I would believe that this is the best way to preserve judicial independence is, if you have ever been a litigant or a litigator, the behemoth in the room, if there happens to be an opposite party and if it happens to be the state, is always the state. The state, if you look at the statistics, the state is actually the most litigious entity in the country, going by any number of studies, including the National Litigation Policy. And when the bargaining power between two parties is practically non-existent, I would expect that you offset that difference in bargaining power by ensuring maximum possible neutrality of the person who operates or who sits in that particular position. There are two ways that you can look at this particular issue, and I hope that the audience considers what I'm trying to say. You can either look at this particular issue through your respective political lenses, in terms of who's in power and who the bench is against, or you can put yourself in the shoes of a litigant or a litigator and ask yourself, are you not better off having a neutral person regardless of who is in power, as opposed to loading the dice depending on the dispensation of the day, or the ideology of the day, or the favorable winds of the day? That's the larger question. And if you look at Constituent Assembly debates, particularly debates which dealt with the draft Article 103, which was the predecessor article to 124, discussions revolved around preserving the independence of the judiciary to the maximum possible extent. And I'm going to say something which could sound classist, elitist, so on and so forth, but nevertheless I think at least somewhere we must have the ability to speak the truth, and the spade must be called a spade. You are not in a position to compare yourself with an America, New Zealand, Australia, or any of these countries, not yet. I'm sorry to say that. I don't think you're in a position to actually say that, where democracy has been fully democratized, where the power of adult suffrage, universal suffrage or franchise is capable of being bought for a biryani packet or a bottle of alcohol, and which is still largely the truth regardless of which part of the country you go to. This is not limited to any particular state or region. I believe that this is a fairly pan-India phenomenon. There I think is unity in diversity. I believe that there must be one check in that place, and that hope has been the judiciary traditionally. And if you look at the track record of the judiciary in this country, every time the executive has failed us, people have reposed faith in the institution of judiciary. Kindly strike a distinction between two different issues. One is judicial accountability and judicial appointment. We are on the question of judicial appointment. It is possible to ensure accountability without interfering with the process of appointment, which means perhaps you could have greater standards of disclosure with respect to assets, greater standards with respect to conflict of interest. You could have greater standards with respect to how a person can be removed from the office. But don't conflate that issue with the question of judicial appointment. If you do so, in my humble submission, you will walk into a trap and you'll forget what the issue is about. Kindly, constantly focus on the issue. The three central words would be judicial, appointment, and legislative interference, 4 words. So don't conflate the legislature with the executive. Don't conflate appointments with accountability.
So,
Thank you.
There we go. Okay, thank you.